Our next case is True Care Physical Therapy versus Auto Club Group. Good morning. This is a 15-minute mini oral argument on the application. You may save time for rebuttal, but we ask that you keep track of that time.
Yes, Your Honor. I'd like to reserve Jim Gross for the Auto Club. I'd like to reserve any unused time for rebuttal, not less than 3 minutes.
I'm sorry. Can you say that again?
Not less than 3 minutes. I'd also like to use a few minutes of my fire-free zone to talk about why we're here. In 2019, the legislature enacted a bill, 2019 PA 21, in order to curb what this court quoted, to curb what had been perceived as exploitative billing by medical providers. To that end, the legislature created a new statute which conditioned a provider's treatment of a motor vehicle accident victim on its agreement to comply with the decision of the Department of Insurance and Financial Services, DIFS, as to whether that treatment was within medically accepted standards as to the nature and extent of the treatment provided. The legislature then directed DIFS to establish criteria or standards for insurers to employ in their review of the appropriateness of the duration, frequency, and length of time of the treatment. The legislature then directed that a provider be allowed to appeal an insurer's adverse utilization review to DIFS, which would render the decision that the provider agreed to comply with as a condition of rendering the treatment in the first place. The major premise of the Auto Club's position is that the legislature did all that in order to curb exploitative billing by medical providers. Jury trials weren't working. We tried that for 40 years, which is why this court in Andrew recognized that the purpose of that public act was to curb exploitative billing by medical providers. The minor premise of our argument is that reform legislation such as this cannot be effective when the targets are allowed to opt out. Jury trials weren't working. We've already tried that. The conclusion is that holding that compliance with the administrative process is voluntary would totally gut the purpose of the act itself. The issue before this court is not whether may means shall. Quibbling over that issue turns the process of statutory construction on its head. Which of the two interpretations is given turns on the intent of the legislature in enacting the law in the first place.
Counsel, I want to just ask you about, I tend to agree with you. The reason the process was set up was clearly to combat fraud. I think there were a lot of public discussions about that at the time the amendments happened, and the language is pretty clear what, sort of the purpose was. How do we square that, though, with these healthcare providers supposed to have a direct cause of action? I mean, obviously that's why we're here today. Like, I mean, as a practical matter, sort of like the nuts and bolts, how would it work? So it's just one process or the other? Is that it?
Well, to answer your first question, it is one process or the other. You don't try this process, and if you lose, you go to 3112. What the legislature did was to carve out a category. Well, you're talking about the general specific. Let's go to that directly. You're talking about 3112, which is on its face conflicts with the purpose of Section 3157A. Conflicts with the intended purpose. For resolution of that conflict, we go to this court's recent decision in Milne versus Robinson, October 2023, I think. This court has said that in such circumstances, courts generally presume that the legislature gave more deliberate consideration to the specific issue when enacting the more specific statute, and therefore they treat that provision as an exception to the General Act. And that the general specific analysis is most applicable in a situation where the two statutes are in pari materia, which they plainly are here, they're both part of the same act, and where one addresses a broader topic while the other addresses a subset of the situation within that broader topic. That's what this court has taught us about this situation. Here, 3112 addresses all provider claim denials, covers them all on its face. 3157 addresses a subset of claim denials to providers, those which turn on the standards promulgated for utilization review. A holding the 3112 controls in these situations, as I indicated earlier, would render 3157A utterly useless. Nobody's going to do what they do in order to lose money. Allowing the targets of the reform to opt out cuts it. Holding the 3157...
Mr. Gross, I want to just ask you, would it in fact be useless? Because let's say, such as in this case, at the undergoing the DIFS review, right, is at the request or initiation of the insurer, right?
Sorry?
The undergoing a DIFS review is at the initiation of the insurer, right? I mean,
the insurer renders the evaluation.
Okay,
And if it's
so you're saying that would be utterly useless if providers were otherwise able to maintain their own action.
Right.
But is it useless? Because, I mean, or wouldn't it be that that a provider, bears some risk, right? They could go and lose the DIFS, the utilization review, right, and not appeal it, and maintain their cause of action, but they may have consequences to having lost that review, right? In the lawsuit, wouldn't the insurer be saying, look we went through this review, they had an opportunity to dispute these causes. It's not just us saying it, it's DIFS who has said that this is that. I mean, you present that claim to the jury, even if it's not outright estoppel, which it may not be, you have pretty persuasive evidence, or potentially, to support a defense of a provider suit. So it's not that there's no role for that, and they go through it and appeal or not appeal at their peril to it being adverse to them in their action should they decide to sue.
The short answer is the legislature decided that jury trials don't work. You've described nothing different than the normal jury trial before the act. The plaintiff, well, the defense is going to have an expert, obviously, saying if they're going to challenge the necessity of the extra treatment, they're going to go in with an expert. The plaintiff, of course, is going to have his provider setting up there saying, you can trust me, this person's seriously injured, he needs this treatment, and I'm his doctor and I know best. That's not going to work. Second, let's take the facts of this case and see how likely it is to have had what kind of effect. The medically accepted standards in this case for this injury, for this treatment, 10 visits over a period of 8 weeks. We're here because this was denied, because at the time of the denial, we had 137 treatments over a period of 2 years at the modest fee of $700 to $900 per visit. Now, let's take that big, huge number, put it in front of a jury, and what's the likelihood of the jury limiting them to 10 visits over a period of 8 weeks? I'd say it's pretty close to zero. So that's not going to work. You're right. In theory, you're right. It has some effect, because we can go into court and say, that administrative, well, you can't even say the administrative agency. All you're saying is, the insurer disagreed with me. You don't have an agency decision that you can take to the jury and argue, because we don't have one, because the court has allowed the provider to opt out. It's useless.
Just so we're clear, you're saying the claimant you don't think is gonna initiate both processes at the same time?
The provider.
Yeah, the claim, yeah, provider.
No, the provider cannot. If it is a utilization review case, it has to go to diffs. That's what the statute says.
I understand, but you're asking us whether there's a, this case is about whether there's two avenues or whether there's only one, right? Isn't that what the case is about?
Once more?
Whether there's two avenues to contest
Oh,
the
yes.
denial of the claim or only one, isn't that what we're here to
Yes,
discuss?
our position is that 3157A provides the provider's exclusive remedy. where
The point is, in the world where there's two avenues, if we were to so hold, a provider is very unlikely to pursue both at the same time. Would you
The
agree?
provider is very unlikely to bother with the administrative one when he's going to win more money in front of a jury.
And only the provider could invoke the administrative process, right? The insurance company who denied the claim under the utilization theory wouldn't have a right to initiate the administrative process, would they?
That's correct, because the insurer is not going to appeal from its own decision.
They're not aggrieved.
Right.
Okay.
Counsel, what doesn't fall under the utilization review process?
Subsection 4,
I'm just trying to figure out if,
I'm trying,
yeah, I mean, is it most things are gonna be
No.
subject to this, or is it
No,
just
let
these repeat appointments,
the legislature made its area of concern pretty plain. In subsection 4, the standards that it wants they're looking at 4 different things. One, and this is directly out of 3157A4, the treatment's not usually associated with this type of injury. That would render it inappropriate. It's longer in duration than is medically accepted standards for this injury. It is more frequent than is medically accepted for this injury, or, and this is the usual situation, extended over a greater number of treatments, greater period of time than the treatment normally required under medically accepted standards for this type of injury. They were specific about that. So that is the answer. Unless the panel has any more questions.
You're right at 3 minutes.
Thank you, Your Honor.
Good morning. Mark Ronzado on behalf of the plaintiff appellee. If there's a self-imposed limitation on the asking of questions, I waive it. The Court of Appeals got this case correct.
Why would the legislature pass a statute like this?
This is a very, very good question.
I'm known for those.
It's very important that the two very significant provisions were part of the same public act, 2019 PA 21. And they created 2 new avenues, if you take into account covenant, okay, because 3112 was a new avenue that the legislator created for providers. And then they did this 3157A, which Mr. Gross is trying to tell you was some sort of carve-out from 3112. But the fact is, if there is a carve-out, the legislature's got to tell us. And they didn't tell us. And that's the essence of this case. Because there are
You're making me forget what my original question was.
Say it again, I'm sorry.
You're making me forget what my original question was, but I just remembered it, so I'm going to ask it again. Why would the legislature pass a provision like 3157A? I know why they passed 3112. I was around when covenant was decided. But why would they pass a provision like 500.3157A?
Well,
Did they just like the way it looks?
the
They think it's a nice
DIFS
idea, or?
The DIFS had a suggestion in the administrative stuff that preceded the adopting of the rules. In their regulatory impact statement, they suggested that 3157A was designed as an alternative to litigation. In other words, a speedier, less expensive way if a wronged provider chose to use it.
What would make a plaintiff's lawyer advise his or her client to pursue the administrative process instead of file a claim in court? What considerations might go into that?
I would suggest to you that the key word to your question is the word lawyer, because there is, at least the agency, when it was adopting its rules, suggested that this was something that could be done without litigation. And that is something that the legislature could have had in mind.
So you're acknowledging that no plaintiff's lawyer would advise their client to
I'm
pursue
sorry?
that avenue? Are you acknowledging that no plaintiff's lawyer would advise their client to pursue the
Well,
administrative approach?
I would think in the vast majority of cases, I can't quibble with this, in the vast majority of cases, the fact is that the plaintiff would opt, the plaintiff's lawyer would opt for 3112.
So
But
the
the point-
legislature was hoping to catch people unawares before they retain counsel? That's the goal or the target of this provision?
Well, the point is that 3112 exists. 3112 is there. It is something that basically overruled, if you will, your decision in covenant. It provided an express cause of action for providers. The fact is that if 3157 was a mandatory
I
detour.
have both provisions up here. I promise I'm thinking about both provisions, but I'm just kind of dialing in on 3157A because I'm trying to figure out what the legislature might have been trying to accomplish when they enacted it. What I'm getting from you so far is they were hoping that people who were not getting legal advice might be duped into following this administrative process, and thereby the system would gain some efficiencies. Is that what you think their motivation was, or is there another one?
Let me answer this question. The intent of the legislature, as this court has told me over the last 20 years, is to be derived from the words they use. That's the intent, the only intent I can talk to you about. I do not read legislative minds. The fact is that the intent is in these words, and they did two things when they passed 3157A. They said may, you may take an appeal. That is not mandatory language. The fact is it's permissive. Now, Mr. Gross has been able to find a couple of cases where there was, in fact, a determination that perhaps the may could be transformed into a shall or a must. But the fact is, they did not put into this, the 3157A, must. And more importantly, perhaps, and it was certainly the subject of the Court of Appeals' opinion in this case, the fact is that they passed 3112 at the same time, which said, providers, you can go this way. Anytime you have a denial of benefits, you can go 3112's direction. That's what they were told. Now, if there's going to be some putting together of these two things, you have to find that intent in this language. You've instructed me on that many, many times. Okay?
I'm glad that you're accepting that interpretive point about statutory purpose. I think that's good. But we still have to think a little bit about whether we're rendering this section nugatory. Why doesn't your theory render 3157A nugatory?
It's not nugatory because it's there, and it can be used as an alternative. It's there. What can I tell you? It can be used
by someone
Okay,
who...
whether it gets used, I don't know, and quite frankly, I don't care. The fact is, it's there.
You
It
think
is-
the-
And if the legislature made a mistake and said may and they meant must, they can change it. They can put it back to what you think they've meant. But the fact is, they deliberately told providers, you can go to court with any claim, and the suggestion is made that this is some sort of carve-out. But if it is a carve-out, the legislature has to tell us. Now, I did some rather unimaginative, but I thought illuminating research. Okay, I took 2019 PA 21. I took that piece of legislation, as you probably know, it was a big piece of legislation, and I put into the computer is to see if any of these subsections of the No Fault Act began with except as provided in, okay? So if the legislature had so chosen, they could have put into 3112, except as provided in 3157A. In other words, providers, you can go this way, except when this process that they created in 3157A is used. That was done, my research showed me, 14 times in 2019 PA 21, 14 times. And they didn't do it here. Clear, okay? They could have gone the other way, as I pointed out in my brief, okay? They could have taken 3157A and said, at the beginning of that provision, notwithstanding any other provision of the No Fault Act. I ran that one through the computer for 2019 PA 21, and there were 3 examples of that, just in that piece of legislation, where they said, notwithstanding any other provision.
Let's stipulate that they could have done a better job, the legislature, on this provision, maybe on the other provisions of the No Fault Act as well. This court spends a lot of time trying to figure out what the various provisions of that statute mean. The question is, I think, if we rule as you're suggesting we should, does that render this entire section nugatory? I mean, is it pretty much wiped off the books because no reasonably well-informed person would pursue this avenue?
It's not, I don't know how to answer the question other than to tell you that. The DIFS has a suggestion as to why it could be used in certain circumstances. Okay? It's not nugatory precisely because it's there, and it's there to be used. Whether it is used is beyond my knowledge. But the fact is, you can't say it's nugatory when, in point of fact, it's there, and it's there to be used.
Mr. Granzato, is this process, the 3157A process, the utilization review, is it either in practice or, I mean, I guess most relevantly by the statutory language, is it only able to be used upon the denial of a claim by an insurer, or could an insurer seek a DIFS review or seek this review process in order to determine whether or not they should pay or deny a benefit?
Well, no, the 3157A5 specifically confines it, seems to me, has to confine it to the provider's appeal. The provider who is aggrieved by a utilization review can in fact use this process.
So they could use it, say an insurer gets a claim that, I don't know, in this, if the standard or the recommendation is 10 visits, but they have a claim that actually this individual needs 15 visits. And they're not sure whether or not that's in fact justified under this situation. Could they submit or participate in this utilization review in order to help them form their decision of whether or not to pay that claim or deny it?
Well, I assume...
In order to get sort of another perspective of this doesn't look like it is. I mean, it doesn't say that upon the denial of a claim, right? I mean, I'm trying to see if whether or not that's actually done in practice is another question, I suppose. But based on the language, it doesn't seem to suggest that an insurer is limited to having this sort of evaluation, this review of the reasonableness of the length or the frequency or the type of treatment only upon having denied a claim.
It is only upon a denial.
It is?
Subsection 5 says if an insurer finds overutilization or otherwise inappropriate treatment, and obviously the denial is assumed in this as a result of that determination, that the physician or whatever, the treater, may appeal the determination to the department under the procedures provided in subsection 3. So it is only the
Only
provider.
upon a denial by the insurer or the catastrophic claims.
Correct.
But the provider can go through diffs and get a decision and then still go to court, correct?
Say again, I'm sorry.
It's okay. The provider can utilize the process through diffs and get a decision and then still file suit.
Well, if you're talking about this case, that's exactly what happened in this case. The utilization review was implemented by the insurer. They arrived at their determination that this was overutilization, and the plaintiff went to circuit court under 3112. That's what happened in
But they
this
didn't
case.
appeal to diffs.
They did not appeal.
So
They
my,
didn't-
so my question is, can they appeal to diffs and also go to file a suit in circuit court?
Well, you can appeal, if they went through the administrative process, I believe the Administrative Procedures Act would apply, and there are appellate remedies from under the Administrative Procedures Act. Not an expert in it, but it would be subject to different standards of review in the circuit court than the 3112 case would.
So it's one or the other. You can't do both at the same time.
Well,
Not at the same time, can you do them at different
yeah,
times
I
even?
don't think you would ever do that. It would be a waste of your time.
Right, but if
It's
it's coming out of diffs, that would
If
be
it-
the agency, the APA, Administrative Procedures Act
Yeah,
rules.
but this.
But if you get a
I'm-
decision from diffs that you don't like, what language in the statute is preventing you from filing suit?
Well,
Brand new, as though you didn't go to diffs. Is there anything in here
Yes,
that's?
our position is that it's 3112 that allows you to file suit, because all you need is a denial of benefits, and that's exactly what this is. So.
So
the-
even if you get a decision, even if you appeal to diffs and get a decision that you do not like, you can still go under 3112.
Well, from this denial, yes, you can go under 3112. That was the essence of the Court of Appeals decision in this case. And that's because this is not an exclusive remedy. It doesn't say shall go the administrative route. And at the same time and in the same public act, they gave providers
So
this
let me
alternative mechanism.
Let me see if I understand this. The legislature thought they would make the process more efficient by allowing for two cases in two different forums to proceed at the same time over the same issue. It's brilliant, isn't it?
Well, my answer would be the same I gave you before, and that is, if we are looking for the intent of the legislature, you have to look at the words that the legislature used. And that means you have to look at 3157A and its key word may, and you have to look at 3112 because that's the alternative mechanism. You know, it's interesting, when I did the research in this case, there's a lot of stuff that says you in courts interpreting legislative language have to presume that the legislature was aware of the law that existed when they were writing a piece of legislation. I couldn't find, I guess it's just too obvious, that you have to presume that the legislature is aware of the law they're writing. You have to be aware of the fact that the entire statute is going to be read as a whole. That's the presumption, interestingly, that applies in this case.
Counsel, so I just want to, I know we're out of time, but I want to ask one more question. So for those of us who have not been here the last 20 years, and actually maybe do look at purpose when a statute conflicts or is confusing, how do we rectify the position you're advocating for with, we know there was a concern about fraud. We know that this was a huge part of the debate for the No-Fault Act, huge part. Lots of the limits they put in place that this court has opined on were put in place because of concerns of overuse and fraud, particularly in cases like the one you have, where it's lots of appointments, allegations that the charges are too high. What about sort of your position helps address that concern?
I don't quite know how to answer this question. Again, you're getting into purpose. And the fact is that we're not here to talk about legislative purpose. We are here to talk about legislative intent. And the legislative intent goes back to words. And you can, Mr. Gross likes to talk about purpose. What was the real purpose behind these 2019 reforms, okay? But
Where have you been the past 6 years? We've been moving towards purpose.
that's
I know I can make you
a
smile.
very important movement, in my opinion. It's true.
Wait, you're on that movement now? You just told me you were on my movement.
You know,
Which is it?
I was urging this movement for about 19 years.
All right, thank you, Mr.
I'm
Hunter.
sorry, thank you.
Mr. Gross, how do you respond to the point raised in the Court of Appeals opinion that by interpreting may as must in 3157A, you essentially shorten the limitations period for actions under 3112?
Well, let me start with what I called the plaintiff's flagship case, Smith versus School Board. Deals with may versus must, and it says, Mark quotes it for saying, when you use must and may in the same statute, you have to give them their natural meaning. Here's what this court said. Here the legislature has used both may and shall, and we should give them their ordinary and accepted meaning, unless so to do so would frustrate the legislative intent. It is always about legislative intent and legislative purpose. Being there, all canons of statutory construction are subject to the intent of the legislature. You do not determine the intent of the legislature from individual words in individual sections of the statute. You look at what the legislature was attempting to accomplish. You've already told us what the legislature was attempting to accomplish in Andery. It was to curb exploitative medical billing. And if there was ever an example of that, it's what we have in this case. Being there and being unused guts the statute. If nobody is subject to it, this court is telling us that despite what the legislature wanted, providers are not limited by medically accepted standards as to how often they should treat or how many treatments per week. All the legislature wanted to do was to apply some limits on exploitative medical billing, took a reasonable approach, let's apply medically accepted standards. As to how this works, Justice Kavanaugh has raised it a couple of times, the legislature instructed DIFs to establish criteria to determine those four things that I mentioned earlier: appropriateness, duration, frequency. DIFs instructed each insurer is obligated to undergo that type of review of every claim. They're supposed to look at it. The insurers look at that because they've been told to do so, because that's what 3157 contemplates. Now, if you're going to have them do so and deny the claim, you're well within, well, first of all, when you're dealing with utilization or review, you're within 3157 anyway. So you've gone through the process that the legislature promulgated to address this problem. You've had an adverse result, and the legislature says, now what? Now the insurer goes to DIFs, an agency with some expertise in the area who understands what medically accepted standards are and will recognize bull feathers when it's being thrown at them. Juries didn't work, an agency will work.
Just as a practical matter, is if we were to agree with you and say that all of these claims need to be processed through DIFs, is DIFs as currently constituted capable? I mean, are they sufficiently in number and in funds and all of these things to now handle every sort of provider claim regarding these type of claims?
Well, I don't know what these types of claims is.
Well, what the statute says, that any claim that involves a
137.
challenge that the charges are longer in duration, are not associated with the right treatment, are more frequent than, extend over a number of days. All of these claims, such as yours, from every provider
Right.
in the state of Michigan,
Right.
and that if we're, say that obviously the legislature wanted to funnel all of this to diffs.
No. The only things that go to diffs, if diffs becomes overwhelmed, because every claim goes to diffs, it proves what the legislature's point was, because it means that every provider in this state is violating medically accepted standards. The only cases that find their way up that diffs ladder into that appeal are cases which have been determined to be outside medically accepted standards. A case like this, 10 treatments, 8 weeks, 137 treatments, 2 years, not a hard one to spot. The insurers review these cases like they're sifting them out. Some are going to get missed, some are going to get caught. But when they catch one, they deny it and they tell the provider, too many treatments. Now, the provider, by the way, can respond and explain. They haven't bothered to do so here because they probably know where that's going to come out. And if the provider is dissatisfied with that result, then it goes to diffs, and then diffs has to hear the case and decide it according to the administrative standard. So, I mean, if we have a flood of these cases going into diffs,
Well, okay, so assume that it's not a flood of cases. It's all the cases that are currently being filed in circuit court shift over to diffs. So let's say it's
all cases which,
that are currently being filed in circuit court.
well, no, of course not. Because all of the cases in circuit court aren't being opposed because of
Cases that are similar,
Yeah.
Isn't it an issue, but you're saying it's up to the insured, let's say the opposite, it's not, it's sort of understood that 10 visits is reasonable, and here there's 134 visits. Say we know that 10 visits is reasonable, and the insurer says it's 1. That's what I think,
Well,
and I'm gonna submit it to diffs and say that that's reasonable, and let's say they're successful in
Well, then
doing
the
that.
insurer has made an
So
unlawful-
I mean, it's the insurer's determination, one way or the other, correctly, perhaps in some, and not in others, will now be funneled through the diffs administrative process.
It is not the insurer's decision. The insurer has to decide it under medically accepted standards. diffs required each insurer to adopt I think it's the American College of Environmental and Occupational Medicine standards. I mean, if the standards say 10, the carrier's not entitled to say 1. I mean, they would be partially punished, I would hope, that you don't see any of that. And you're asking me what to do if somebody does something unlawful. That's not the way it's supposed to work. The way it's supposed to work is they get looked at. If they violate the medically accepted standards, the insurer says so, says no. And if the provider is happy with that, it goes to diffs, makes its case, and we've kept the case away from the jury, and we're not paying, $150,000 on a case like this.
thank you very much. Thank you both. The case will be
Thank you, Your Honor.
submitted.